Welcome back, ladies and gentlemen, for this afternoon session. My name is Anselm Kamperman-Sanders. I'm Professor of Intellectual Property at this university and a Deputy Judge in the Court of Appeal in The Hague, dealing predominantly with patent matters there. For this session, which focuses on green and digital transitions in the interface between intellectual property and competition law, we have a number of speakers that will deal with the issue of intellectual property functioning either as a conduit or a barrier to repair, recycle, and the circular economy itself. And it's with great pleasure then that we have our first keynote speaker to address you on this issue. From a faraway place, Australia. So Deanne Wiseman is very much an expert on the field, and she has also received a grant to go into the issue of exploration of the right to repair and circular economy. And she's done a lot of comparative work in the field, and it is therefore a pleasure to introduce her now to you, and I would like to immediately give you the floor.
Thank you very much, Anselm. Yeah. Very quick. Well, thank you very much for the invitation, and thank you, Anselm. It's wonderful to be here. I really appreciate the opportunity to speak to you about how intellectual property is operating really as a barrier in many ways to what we all now know is the emerging or already established international right to repair movement. Firstly, I'd like to acknowledge my two co-authors on a piece that we have worked on around this topic is Anthony Rosborough and Taina Piharan from University of Helsinki. So to begin, I think it's a good time to reflect on the different roles that we see with intellectual property. We all know that one of the key policy underpinnings of IP is about balance. We always hear the language of balance and about striking the right balance between rights holders and consumers or users or anyone really who wants to seek to access and use intellectual property. We also know that the aim of the circular economy is to essentially reduce waste, optimize the use of resources, reuse, repair, recycle, and ensure that we have sustainable supply and responsible consumption. Now, intellectual property and WIPO would have you believe that IP is doing a wonderful job with sustainability. We know that all of our IP officers' KPIs really are how many green patents, how many green trademarks are being registered. Aren't we doing well in the sustainability realm? The reality is that many IP rights operate in a way that actually hinders us in our move to a circular economy. So I'd like to talk about some of the barriers that I see with respect to intellectual property. What's really interesting is coming to the right to repair movement is that intellectual property is now in everyday items. So particularly, and the focus of my talk today is on copyright, but what we're seeing in a lot of regulatory regimes is people are still thinking about the consumers of copyright works are libraries, archives, and educational institutions. So they're really thinking about the traditional category of works. They're not really thinking about toasters, appliances, ventilators, insulin pumps, tractors, and cars. And all of these machines and devices have copyright in them now. So any smart device that we have, and you can cross all of these subject areas, they all have, if they're smart devices, they'll have software embedded in them, and therefore they'll have copyright that protects that software that's embedded in those devices. Most regulators that we're looking at that are talking about reform to copyright law are still dealing with orphan works, Broadcast Treaty, Marrakesh. No one is talking really about these barriers that copyright is presenting to us being able to keep our dishwasher in use for longer. So how do we get here? We know that all of these smart devices, we know that there's a crisis. The biggest global increase is in e-waste, for example. Essentially, the way products are being made now means that there are a range of barriers. There's physical, legal, technological barriers that exist in products. So they're using product design, we know that, the way things are being made. Fundamental to many of the barriers are intellectual property rights. The fact that there are TPMs or digital locks over these devices because there is the embedded software in these devices. The contracts that accompany the software or the smartness in these machines, the end-use license agreements contain terms that override copyright defences. I've spent many years reading John Deere tractor contract licenses, and I can tell you that all of their license agreements, when you switch on a John Deere tractor, will say that you cannot modify, access, or tamper with any of the software that's embedded in that tractor. A perfect example of using a legal contract to override the carefully balanced copyright defences that we have. And also there's physical restriction of spare parts and access to repair information. So all of these matters are really at the heart of why we have such a crisis, the fact that we can't continue to use these devices. So just speaking briefly about the right to repair, essentially it means a number of things to many different groups and people, but really to tick off a couple of key features is that it advocates that everyone, and we're not talking only about consumers, but everyone, whether that be a motorist, a farmer, a biomedical technician, a miner, for example, should have the ability to have their smart goods, machines and devices repaired at a competitive price using a repairer of their choice. What's really interesting about where repair intersects with a whole range of legal regimes, it touches on competition law because of the secondary markets that are so fundamentally important, but it also touches on consumer rights and consumer law, intellectual property law, environmental law, waste resource policy. So it's a multifaceted problem. What we mean when we talk about right to repair is essentially that, and what I would like to focus on today is independent repairers and consumers should have access to not only the physical spare parts, and there's a lot of great work that's been done around provision of spare parts, but access to the necessary information and equipment needed to repair those products, including access to embedded software in the products, so the diagnostic software that's in the products. They should have choice of repairer with price competition in those aftermarkets, in the service and repair markets. They should be able to buy products that are able to be disassembled, that are repairable, that are durable. It recognises the role that repair and reuse can play in reducing e-waste and encourages the growth of the circular economy. But really at its heart, we're talking about rebalancing the relationship between the manufacturer of products and those of us who buy and own those products. The inability to repair really strikes at your ownership rights. When you buy a car, if you can't open the bonnet and fix that car, the question is asked, do you really own that car in the physical sense? So we know that the EU has, for decades, been working to improve access to repair. There are so many different, I'll take you on a bit of a quick glide through this. The great work that's been done in the Eco-Design Directive about original equipment manufacturers or OEMs being required to supply their spare parts to certain products. Eco-design regulations that leave discretion to OEMs around, this is one of the problems, about how much those spare parts will cost, how accessible they are, how available they are, and whether common tools can be used or not. And it does actually limit repair to professional or commercial repairers, not everyday people, for example. We know that in the Green Deal, the Circular Economy Action Plan, one of the key pillars really sees right to repair as a suite of consumer rights, really with the idea of environmental sustainability as its goal. Deals with warranties, product guarantees, repairability information at the point of sale, and that's great. It really informs the consumer whether to buy product A or B. It does make mention of allowing updates of software, and there is mention there about intellectual property rights that enable the green transition through innovation and digitalization. Not quite sure what that means, but so there's new reforms coming. We've got the new consumer agenda. We know that many consumers are keen to keep their white goods in operation. I think everyone in the room here does not get any joy in buying a new refrigerator, a new washing machine, or a new dishwasher. Everyone probably would just like it to keep working forever. It's not a consumable that you kind of want to buy. It's not like a new iPhone, for example. So there's really in high percentage of consumers who say manufacturers really should be required and mandated to make things easier to repair, to make sure that they can be parts available and information provided. So all of the new implementation acts around the Eco-Design Directive, Eco-Label rules, for example, are all aimed at improving access to spare parts, looking at repair manuals and making, again, manuals available to professional repairers. Just this year, we know that there was a really big announcement around right to repair reforms here in Europe, amendments to the Sale of Goods Act, amendments around sustainable products, the battery regulations. There's a whole lot happening. What I'd like to kind of highlight to you, if you talk to a farmer whose tractor breaks down at harvest time, it is not the availability of spare parts that is his problem. It is the problem that his tractor is bricked. And that means he cannot do anything to that tractor. If he does, the tractor will stop working and it will be remotely shut down. Similarly with smart cars now, if you try to tamper with certain aspects of the software in the car can be remotely stopped. So having spare parts available is fantastic, but unless you can get around the software locks and the software that's in those devices, you'll never even know which spare part that you need. So getting around, we look at all of the kind of responses that are happening around the world to repairability. A lot of them are really being presented as remedies, consumer rights, competition, addressing competition in the market. If we think about it a different way and look at what is the source, what is the problem with getting things repaired, and often we can argue it's the IP barriers that really are the source of some of the barriers. So this little diagram was provided by our Productivity Commission in Australia. It's an economic think tank. I love the fact that they use a tractor as an example of what a product is. But they just say, look, a single product's covered by a lot of intellectual property protections. We can see them: copyright in the manuals, repair information, onboard computer with copyright, digital tools, contractual terms, everything. So we know that IP is ever present in these everyday products that we're using. So patents, we know, trademarks, we know, but if we focus on the copyright, and we're talking about copyright and the TPMs under the copyright regimes. Interestingly, in Australia, as I said, the Australian government commissioned a Productivity Commission to do a national inquiry into the barriers of repairability in Australia. Now, I know we're a very small market. In fact, in Australia, we don't make or manufacture very many things. We certainly don't make cars, but we fix them. Fixing cars in Australia is a $43 billion industry. So it's important that we be able to fix cars and tractors and all the consumable goods that we import and use. They identified that one of the unnecessary and IP-related barriers to repair were in fact copyright laws that prevent third-party repairers from accessing the repair information. And they thought that these laws do not strike the right balance between the interests of rights holders and those seeking to access and use those materials for the purposes of undertaking repair. Remember, repair is not just about fixing things, but repair is really about rethinking replacement and thinking reuse. And this will really help us on our way to a greener, more circular economy. So Australia has a series of recommendations about how we can broaden our exceptions to allow for repair, whether that's the adoption of the US fair use. We always have that presented to us, but it was proposed that we have a specific fair dealing defence for repair as well. What's interesting, I think, and really important to note, and this is not the first time Australia has had this recommendation made to it, is that to make sure any defence in copyright is effective, you need to accompany that with a provision that prevents contracting out of those defences. We have one in Australia, Section 47H of our Copyright Act is there, and it's an express provision that stops you from contracting out of backing up a software program. So we have precedent. But you can have all the defences in the world, but if the contracts and the EULAs override those defences, then you have nothing. So this is a really important recommendation. There are also recommendations around how we can improve our TPM regime to make sure that repairers can access not only the tools, but the information that they need to get behind these digital locks. In Australia, what's quite unique in some respects is the fact that we have just implemented a new regime for mandatory data sharing for automotive repair. I know that the European Union has something similar, but ours takes on a little bit of a different tact. So in 2017, when we stopped making cars and cars were being imported, it was recognised that there were serious competition issues with the fact that people had to return their vehicles to authorised repairers and not be able to take their vehicle anywhere else. There's a lot of confusion with members of the public around the existence of their warranties, whether they're obliged to, will their warranty be voided if they go outside of that authorised network? A lot of work has gone into the aftermarket, educating people that you can take your car anywhere to during your 5 or 10 year warranty period. But it was recognised, and there was an MOU arrangement between global manufacturers and the Australian aftermarket in motor vehicles that diagnostic and software information would be shared to enable repair. So you could take your BMW down to your local mechanic and they could plug it in and get access to the diagnostic software that they need to know whether your oil blend is incorrect or your brakes aren't working, for example. So it was suggested by our competition authority that we have a mandatory scheme. Fast forward 2 years, essentially. It's now been in operation 1 year. What is so good about this system, and I will blow our own trumpet here a little bit, is that this amendment came in through our consumer law. It is a whole standalone regime. It is called the Motor Vehicle Service and Repair Information Sharing Scheme, and it is an amendment to our Australian consumer law. What is really interesting is what is excluded from this regime. And it says the following information is excluded from being scheme information, and that is scheme information that must be shared by global car manufacturers. And you'll notice something that's a trade secret or something that's intellectual property other than intellectual property protected by the Copyright Act. So what they have just done is blown copyright protection out of the water for global car manufacturers, because this whole scheme says we respect your intellectual property, The big two arguments manufacturers come back with as to why you can't repair and shouldn't repair your goods is one, it's always a safety issue. You're going to kill yourself or you're going to kill someone else. We hear that from the medical technicians, you know, from the Medical Association and the Medical Technology Association all the time. The other one is, and it's our intellectual property. And it's really interesting, you have this conversation, which intellectual property are you referring to? People just want to be able to change their wiper on their car, for example. There's not stealing or copying or infringing any patents in the technology, but gaining access to the system to work out what needs to be done is really what's being sought. So this scheme, because it is in part of our Australian consumer law, our ACCC, our competition authority, has responsibility for that. So what that means is they now have an office and a staff of 7 people who will enforce this. So global manufacturers who breach and don't provide the information, there is a potential for a $10 million fine. That is the kind of system where we can use a stick with some of the manufacturers to say, you will do this, and there is no reason why you can't do that. So that's an interesting model. It's much better than a defense of fair dealing in the Copyright Act to say that you must. And there is now an independent body that will set a reasonable rate, etc. So I think that's an interesting response from a regulatory response. I've just put a really cute tree kangaroo because I thought at this point you'd all just be a little bit tired after lunch. This is a tree kangaroo that just had a baby in Australia, and we're very proud of it. But EU law and the right to repair, I just thought I'd move quickly through this for you, but that's just a bit of light relief. So we know when we're looking at all, and I'll just say this briefly, but when we look at all of the fantastic work, and some of it is examples of global leadership around manufacturer responsibility, design regulation, product regulation in the EU, we've got so much directives and regulations around copyright law. We know that Article 11 of the treaty and the functioning of the EU really talks about promoting sustainability, and this applies to everything. So it includes IPRs. So we must be taking sustainable development into mind when we're looking at the way in which our copyright laws and our TPM laws are being operating in practice. I think a lot of our regulators forget that it's actually in your household in all of those devices. So TPM policy, again, is really where there needs to be more thought given to sustainable development goals, environmental sustainability. Do we want everyday devices locked up or bricked by a TPM that was really brought into our copyright systems to protect online music, online works back when we first had the internet? So we're looking at schemes now that are stopping for example, your dishwasher is connected to the internet. You can't put a load on while it's updating its software. I mean, do people really want dishwashers that connect to the internet? I don't think that convenience factor is there, but it's often difficult to buy something that's not extremely high tech. So what I would kind of ask the question is, we need to, when we're thinking more about environmental sustainability and the role that intellectual property law plays, we can't forget about the role that copyright and TPMs are playing in creating barriers to all of the good work that is being done on product longevity and making our products more durable. So if we argue that repair furthers a very important public interest in terms of sustainability, waste reduction, knowledge production, there's a intergenerational skills transfer. It creates a very valuable secondary market for those who can't afford to buy new, and it also improves consumer choice. So it's important that when we're looking at policy responses to the right to repair, that intellectual property should be part of that response, and not only in terms of a positive assertion of rights over green technologies, but looking at how it can be rebalanced to allow ownership rights to really trump IP in some instances. Thank you very much.
And here was I just realizing that my dishwasher is off, as is my oven and some other appliances at home. So all is good. Okay, thank you very much. It is now my task to sort of continue this discussion somewhat, if I can find my presentation somewhere. Can you open the slides for me? Yes, good.
Yeah.
That means that while my slides are being opened, I don't have to multitask, which is something I cannot do, but that still means that you can ask questions. Any questions at this point in time? Yes.
I was just curious about this exception crafted for the car. Yes. I had a concrete question about this reform that repair should be facilitated in the car repair industry. And so you mentioned how copyright will no longer be a sword that any car manufacturer can use, right? And so I was just wondering that in Europe, one of the swords was design law that has very often been used by car manufacturers. And at European level, you know, that has just been waived. So there is no protection, no design protection over spare parts. But at national level, for example, Germany would never let go. Like the car manufacturers just have a grip on their kind of design rights over spare parts. So was there no debate about that?
There certainly is recognition of the role that design law plays in protection of car spare parts. That was probably a fight for another day. So I think we had our Treasury, our government on side with the fact that your everyday mechanic could not afford to get access to the diagnostic software to work out what is the problem with the vehicle in the first place. The question of which spare parts you can get is really a bit redundant if they can't even do that. So I think the strategy was that if we can get them the diagnostic software access, then there are other opportunities to look at the other forms of intellectual property, reform of designs law, for example, reform of trademark law, patent law. We've just had a High Court decision, which was fantastic around repair. So I think it's quite strategic. The other thing I should say is agriculture and agricultural machinery really wanted to jump on board with that legislation, because the way the vehicles are defined, it's small vehicles. It doesn't cover heavy vehicles and it does not cover agricultural machinery. What was interesting was a political decision to leave agriculture off and go forward with just the car manufacturers. To be honest, they're big enough without taking on Case and John Deere at the same time. So agriculture is sitting here. We have recommendations that agriculture can easily fit within that regime, and access to diagnostic software should be provided to agricultural machinery as well. We're not far off that.
Thank you. I have two questions. One question is, the right to repair under consumer protection legislation. The jurisprudence behind consumer protection legislation focuses on consumerism and buying more goods. So, and the right to repair on the other side says, well, let's not buy so many goods, let's make it sustainable. Do you think that it would be more beneficial if we have a more horizontal legislation, not just limited to consumer protection key of the right to repair? Again, this is a criticism of right to repair being read into consumer protection legislation. But on the other side, in India, this is what we did, where we said, okay, the Ministry of Consumer Affairs stepped in and they said, well, we're going to take right to repair very seriously, and made it mandatory for 4 industries, which is the automotive industry, which includes farming equipment, mobile devices, consumer devices, and I believe one more that I'm completely forgetting. But they made it mandatory for these companies to say that that consumers have the right to repair. What they also did, they said, well, we're going to give out licenses. The company will give out licenses to register third parties where you can go and repair your goods. You don't have to come to the company or Samsung to do it. You can give it to licensed third parties. Do you think that is one of the ways to get around the right to repair, at the same time protecting intellectual property and not just giving it to everyone? So,
yes. I think your first question about consumer rights, and this is, I have a similarly strong feeling about copyright defenses. It's like, I'm a lawyer and an expert. When my dishwasher breaks down, I have all the rights in the world in Australia to pursue that. I cannot sue Samsung or Miele. I will not. If they refuse me, and this is as interplay, our consumer rights legislation is very strong, but it requires me, the individual, to take on someone. No one is funding me. It's not going to be a pro bono exercise. So I think, and similarly with a fair use or a fair dealing defense, you have to wait until you're sued, and then you can go, oh, I've got a defense. It really puts us as individuals in a very weak position to rely upon consumer rights, I think. I would much rather see requirements upon manufacturers who create the products. You design them, you make them, so you tell us how they can be maintained, serviced, cleaned, repaired. And if they can't be repaired, how should they be disposed of? What's the proper recycling or whatever? That product stewardship or producer responsibility for what they're making. I think that is a better model. They've got the money, not the individual people who buy the iPhone, iPod, whatever. So your second question around, I think there's a really, and what's interesting about our motor vehicle data sharing scheme is that the manufacturers are actually making money because they're selling that information. And this is a whole new market that they didn't realize that they had because they were holding it to themselves. We know, we can see the dollars ticking over. They're actually making money from selling their, providing their information at reasonable cost to those independent repairers. And there's thousands of them. So I think that idea that, is their intellectual property going to be undermined by them providing training and authorizing other people outside their network, they can still make money from that. So I don't see in that instance, I mean, in the medical repair device and assistive technologies industries, there's really good, strong examples of people who are in life and death situations who can't get access to reasonable care. Or if your electric wheelchair breaks down and they say it will take 3 weeks to get you a service technician to you, that's a human rights issue. So I think the ability to be able to open, it's essentially called creating a level playing field, which is what we don't currently have.
Any further questions? So perhaps if there is one. Oh, yeah, okay.
Thank you, Professor Weisman, for that wonderful keynote. You left me with more questions. Actually, it left me thinking. And I think one of the last points which you very nicely pick up is talking about creating a level playing field, which is actually true because the issue there is also one of human rights. You give the example of wheelchair, and we have many examples. For example, if you look at the case of digital agriculture, therein, one of the big issues is that there's a huge concentration on the side of the manufacturers. They are getting even more concentrated, getting into digital agriculture. So we have a vertically integrated entity which has access to all my data, equipment, repair on the one side. Then me as a small farmer, I'm in a weak bargaining position. So it is also a bit of a competition law issue. So I was wondering, because I see this as both an IP and a competition law issue, right? And it is often said that because IP has a very nice innovation framework to create incentives to innovate, and competition on the other side from an external framework kind of balances the irregularities that might be in the competition law framework, in the IP framework, the excesses that it creates. And I think one such example would be one of IP overlaps, where in one of the slides you showed the multiplicity of rights, overlapping rights. So I was wondering, in light of this macro picture, how do you see to explore the internal flexibilities in IP law, also looking in the context of these fundamental rights debate, the Charter of Fundamental Rights that we have in the EU, and the more macro framework, because to the extent, if I can correct the wrongs or excesses of IP, I should do it within the IP law framework. And I should look at competition law, for example, abuse of dominance or access to repair or whatever, only at a point in time when I cannot correct it within the balancing framework that I have in IP. So I wanted to hear a little bit more of your thoughts in this context, in the context of digital agriculture particularly, because I know you have huge work over there.
Yes. I think you've touched on some really important things. The interplay between competition law and contract law and IP. The fact, as I gave the example, and I do know digital agriculture very well, and one of the issues that I didn't mention is the issue of interoperability, and that's something that probably you'll be looking at with your EU Data Act, with the kind of IoT connected devices. But this issue of interoperability, that you can't attach a red piece of equipment to a green piece of equipment, case John Deere, and you'll notice that on any slide, there's always two tractors, a red and a green one. It's just politics to make sure that you don't get hatred from both sides of the manufacturing world in ag. But that issue around the fact that the software license will override whatever we have in intellectual property. So we know that intellectual property exemptions take so long, they're so hard fought, they're very narrow, and they are just a defense. So I think of the example, we move away from agriculture, but think of the Marrakesh Treaty. It's a human rights treaty to make sure that copyright really didn't present barriers to people, with disabilities in accessing works. But when you think about someone in a wheelchair, the Marrakesh Treaty and the way in which it's being implemented means that that person could get access to an article about how they could fix their wheelchair, but they couldn't actually do it because of the copyright and software that's in their wheelchair, because the Marrakesh Treaty does not apply to software programs just in terms of the work. So there's these really kind of examples that we can give of the way in which copyright and IP is really, and it's always lagged behind the internet and digitalization. But in agriculture particularly, I know farmers who have two tractors on their farms. They have an older tractor and they have a big shiny new John Deere tractor. And the reason they have the older tractor is they know that that will keep them going through harvest if there's a hailstorm when they need to. This one is here so the banks and the insurance companies know that they're a good farmer and they're a modern farmer. And it does do good work sometimes, but if it breaks, they know they can't do anything with it, so they'll use this one. And that's really examples of how things are working. So that, and you say the competition issues in terms of the global giants that we're looking at, if you look at the top 15 kind of tech firms in agriculture, in medical devices, in mining equipment, it's basically tech firms now. It's not the companies, the brands that we usually know. So we are dealing with different entities and the kind of hardware manufacturers that we're used to. Don't know if that answered your question.
There's also a question.
Hi.
Hi.
Hello.
Yes, please go ahead.
Okay. Thank you very much, Professor Weissman. My name is Damola, and I'm joining from the University of Ottawa. in Canada. So I'm a doctoral student considering the interplay of copyright and competition law for advancing. Oh, sorry, my light is on, not on. Okay, so I'm looking at how copyright could assist in advancing socioeconomic goals in Africa through competition law principles. So this is a very interesting topic. And my question is, copyright, its exceptions and its doctrines are governed by treaties, international obligations. And if we try to deploy competition law principles using the right to repair to ensure that consumers have greater choice, they are able to exercise ownership over their appliances. How can we circumvent the obligations on nations that they have under international law treaties, international copyright treaties? Hello?
Could you speak a bit louder, the last part of your question?
Okay. Can you hear me now?
Yes.
Okay, so there are international law obligations, international copyright obligations.
Yes.
That countries are obliged to follow, even when they are reforming their copyright law. So to circumvent the copyright barriers using competition law principles, in order to ensure that consumers have choices and can exercise their ownership right over their appliances, how should a country or a region like Africa deal with these international obligations in cases of conflict?
Oh, yes. I mean, that's a very good question. In terms of the obligations that we see internationally with copyright law, I mean, it's unlikely that we're going to see any seismic shift in copyright law that will facilitate the ability of individual countries to overcome all those barriers that I spoke about. So that is part of the reason I think it is the role of the interface between IP, competition and contract law. For example, legislation that prohibit unfair terms in contracts, for example. I know that there's examples. That is one opportunity to say these types of contracts that forbid people from prolonging the life of their goods or from restricting them from accessing particular information or spare parts or access to repair information, for example, that they're inherently unfair and therefore unenforceable. That would be great to see, but I see the problem with any unfair terms legislation as well is, again, the responsibility comes back on the individual to highlight those terms and to bring those actions. I'm not sure if that answered your question.
Okay, it's fine. Thank you.
Sorry, thank you.
Yes. Microphone is coming.
Thank you. May I follow some further question? By considering the doctrine of exhaustion, or we call for sale doctrine, yeah, we know the right for repair it makes sense because of the doctrine of exhaustion in the patent law. But we know for the copyright, it's by licensing rather than by sales. So the the software selling is not a kind of, it cannot be applied to a doctrine of equivalence, sorry, the doctrine of exhaustion. So how could you argue against this kind of consideration.
In terms of how do we deal with the copyright?
Copyright have no doctrine of exhaustion.
No, that is
Oh,
true.
But my point is right to repair is reasonable because of the right of doctrine of equivalence. Sorry, doctrine of exhaustions.
Yes.
In the patent law.
Yes.
But there is not such a doctrine application about software in the copyright law.
Yes.
Yeah.
Well, certainly, I think in our Productivity Commission report, it was raised as whether the doctrine of exhaustion should apply to copyright law after our Caladad case. You can imagine our law council, the peak body of lawyers in Australia, was vehemently opposed to that. What I should say is essentially law council also has, I think, not realised that there is a piece of legislation in our consumer law that overrides copyright law. All of our intellectual property law people, I don't think are looking at that, but I think that's an interesting example. But I think you're exactly right, is copyright lasts for, life plus 70 years. And in these devices, that software, that control that the manufacturers can have because of that software and because of the digital locks that they put over that software will long exist, beyond the durability of that particular product. We know that. So that interplay between the fact that the software is protected for so long, they can use part pairing. So that, and that's part of that interoperability. So you can only replace, you can't replace an iPhone battery with another iPhone battery because they won't talk to each other. So that's an extension of their control because of because of the copyright. I think the copyright and software protection that's being given to everyday devices was never envisaged when we talked about TPMs and that whole regime essentially back in the 90s and the 2000s. So I think it really is cause for a reconsideration of the appropriateness of those things in our everyday devices.
Thank you.
And perhaps also interesting to add to this, I mean, in Europe, we do recognize exhaustion for software products as such, as sold.
Yeah, I agree with you.
But as soon as you create this into an IoT setting, then you have a problem.
Yes.
Because it's no longer purely the software as such, but it's intrinsically linked and embedded in a wider online ecosystem. And then in an online setting, copyright works do not exhaust. So that's one problem. We also recognize in law the possibility to repair software, but only for as far as the original supplier does not provide the means for debugging and so that's the repair in software, debugging and so on. So in other words, where we traditionally thought of software products as sort of something also almost physical,
yes.
And transferred, now, of course, everything is online in cloud computing systems and so on and so forth. And all these traditional notions on exhaustion have completely disappeared. If there are no further questions, then my attempt will be to make things even more dramatic. Let's see, where is my presentation here? Thank you very much for that contribution. It allows me to continue somewhat. My paper concerns intellectual property in the circular economy at large. I have to acknowledge my co-author, Professor Dalindyebo Shabalala, who is, apart from being attached to this university, a professor at Suffolk University Law School in Boston. And the paper concerns a policy paper that we were asked to write for the European Parliament in relation to the new consumer agenda. And this also then features issues related to the circular economy. We were asked to keep things very simple for lay people so that they could understand the issues related to the circular economy, the right to repair, and broader aspects. Now, you've already heard a lot about copyright. And copyright is extremely problematic because it potentially makes all of us infringers, whether we act in a private capacity or in a commercial capacity. It makes no difference. So you would expect, when you look at industrial property rights, patents, trademarks, and the like, that the picture would be more positive. That's not the case, I'm afraid. And that is because we are stuck in a system. And my proposition is that if we are to move to a circular economy, we will have to be even more radical in our thinking than talking about limitations and exceptions to copyright or interference by competition authorities, because our economy is, in essence, the result of the efficiency of production through externalization of certain costs. And these are all the costs of disposal, waste, or excess raw materials, and repetitive consumption patterns on the other hand. So, in other words, products are produced according to the principle of planned obsolescence. And intellectual property rights, as we have heard, serve to control and to limit possibilities for repair, but also for recycle. And the traditional industrial design's role will have to be replaced by something else. And that is what is commonly referred to as eco-design. So, stepping outside of the paradigm that currently underlines our economic production system and production cycles. And this will also then require, according to people who study this, for the entire production chain to be sort of reassessed, and for certain parties along the line also to cooperate, possibly in ways they have never done before. And that creates quite a number of problems if we are also looking at intellectual property rights and attempts to actually control parts of the entire value chain, to monopolize parts of the value chain. And so this coordination between actors, all the way from raw material providers to end receivers, and the need to then reduce waste all along the line, and this can be waste as we think in terms of eco-waste or things we discard, but also other types of waste in the production life cycles, requires that we address the segmented circularity and remove these barriers. And this, I think, is such a massive challenge from a regulatory perspective. I cannot deal with this possibly in the scope of this short presentation, but I will try to say something about intellectual property rights in that context. We see this both in agricultural domains, so we have discussions on food to fork or field to fork type of renewable systems, but also we see this in discussions on more industrial processes. It doesn't really matter what type of process we are looking at. In all these types of production cycles, there is a need to look at circularity. Now, we've discussed the right to repair. Basically, what we see are very sector-specific initiatives, like this one, in relation to mobile phones. And the common example that is always lauded is the Fairphone, where you can get and replace your component parts, etc., etc. All very nice, but just sector specific, and as I've stated before, to my mind, not radical enough. Rather, we need to look at the entire value chain and then see where we can address some of these sort of barriers. And if I then overlay that with the rights of industrial and property and copyright, we see that these rights sort of come into play at various stages in the life cycle of products. And they may stand in the way of repair, but also in relation to reuse, refurbishment, or remanufacture, or even recycle. So to my mind, our discussion should even go far beyond the right to repair, but also address the other aspects that stand in the way of repair and recycle. Now, we've heard examples about limits imposed through copyright, but also trademarks play a role. So the Supreme Court of Norway, in as recent as 2020, to my mind, reached a very undesirable decision in relation to somebody who was trying to import into the European Union refurbished iPhone parts. And what he had done was, or what the suppliers had done, is that they had crossed out the Apple trademark logos on these parts. And these Apple logos would only be visible to the repairer had they not been sort of blocked out. The end consumer would never see these because this is for example, at the back of your screen or something like that. Apple, however, sued, saying, well, these could be counterfeit, these could be this, or they could be that. Quite unclear if you look at the case facts what in fact they are. But nevertheless, the Supreme Court in Norway held that this is a misuse of Apple's trademark to sell these screens, and as they were sold as genuine Apple parts. So in other words, it's not about the question whether these are counterfeit products or not. It's just a question as to whether the sale of also reconditioned parts, where it is very common that once the screen is reconditioned, you basically ensure that it is known that these are reconditioned parts. So you cross out the logo, indicate this is reconditioned, still not possible. Now, if we then turn to patents, well, perhaps it's important to state here, as a private consumer, you cannot be sued for trademark infringement if you try to purchase this. But what you see here is a direct attack on the supply line for reconditioned spare parts. Patents then, typically also problematic for as far as the act of refurbishment or remanufacture by a third party without the permission of the patentee also typically would be a violation of the patent right if the repair concerns the inventive component that is covered by the patent. You can have wonderful discussions in court as to whether actually this falls within the scope of the patent, this act of repair, or it does not. But then you are quite a large amount of euros, etc., further down the line. So typically, with one letter of summation, the the party undertaking such refurbishments or remanufacture will cease its operations because the risks are simply too great. So if we then look at eco-design and IP regulations, of course, they have also been mentioned. They are rather sector specific. The only exception possibly being the Community Designs Regulation and Directive, which allows for some must-fit and so-called must-match exceptions to design protection, so that you can not only restore the sort of functional, but also the aesthetic appearance of a product. But as stated as well before, automotive industry interests mean that this may be true at EU level, but at member state level, this is not fully harmonized. And then the sector-specific rules can be found very much on the interface of intellectual property and competition law, specifically in relation to vehicle repair and maintenance information, the Waste Framework Directive, and the Eco-Design Framework Directive. But they don't provide sort of an overall vision on how we should be dealing with this situation. So, to my mind, a radical shift is needed. If eco-design is to be truly effective, this requires a shift in the policy mindset and also a reframing of the purpose of IP protection. Not that easy with all those international treaties in place. So in copyright, perhaps some ways forward in more open innovation and commons licensing practices. I will leave this to be discussed by Leanne. But also in other areas, of course, there is experience with the development of platforms, standards essential, patent licensing, and the like. This could also be used for a two-pronged approach, making sure that the best available technologies and processes for sustainable manufacturing and remanufacturing are in fact available on the basis of a friend licensing. European Commission proposes to set up a standard essential patent sort of authority within the EU Intellectual Property Office. My suggestion would be let them seriously have a look at these types of issues rather than to deal with the rights of right holders. I would have thought that intellectual property offices also have a duty to society and the public at large. This seems to have been forgotten in time. We've heard about copyright, but also what will be required is a closer interaction between competition authorities when it comes to the enforcement of consumer unfriendly restrictions. We've heard about the downsides of this. To what extent can competition authorities solve something that is at the back end, what is not addressed at the front end? And here I'm simply still stuck with these IP rights, where the basic principle is that limitations and exceptions are that limited exceptions for limited circumstances only. Isn't there a way forward then? Well, if I look at my own roles sitting as a deputy judge, sometimes I get frustrated because we have a wonderful principle called the principle of proportionality, which is enshrined in our enforcement directive. And sometimes you are asked to order the destruction of, I don't know how many goods that are sitting somewhere in the harbor where it's not even clear that these are counterfeit goods. But the proprietor of patents, trademarks, or whatever simply says, well, I object to the importation of these goods. And then, of course, the assignee or the ultimate owner doesn't come forward because they already fear the outcome of the case. Everything is basically incinerated. I find this just mind-boggling. And yet proportionality in the context of the so-called IPRED directive, enforcement of intellectual property rights, is placed on an equal footing next to sort of dissuasion of parties to infringe and providing a sort of equitable remedies for and speedy remedies for right holders. Somehow my feeling is that this is not on an equal footing. And if I look at the TRIPS agreement, Article 7 and 8, I think they are not on an equal footing. What has the European Union done here? And then also, if I look indeed in European legislation on fundamental rights, I also think this is not correct. And nevertheless, even if I discuss this with my colleagues, they say, well, in the IPRED directive, it simply says it's on an equal footing. So whatever you want to do with this principle of proportionality of yours and all your fundamental rights, we are not going to go down that route. Leave that to the legislator. I think this is becoming problematic because there is a social bargain underlying the IP system. Some would call it balance, but I think that balance is somewhat lost when it comes to the needs of society facing a radical shift in policy that is necessary if we are to survive on this planet. Thank you very much. It's very funny. Yeah. Now I am the chair again, so I have to do all these duties as well. Sorry. So I have to stop sharing. Yes. And you change. So this is why the chair has an assistant.
I tried to hear that out.
Should be fine.
Yeah, okay. Thank you very much. I found it a very interesting presentation and also very much enjoyed your paper.
Just take money.
Yep. Okay, great. I'm more of a competition expert, not very much an expert in IP, but I did some research in competition and sustainability. So I very much enjoyed this link between IP and sustainability as well. As I, for example, didn't really see beforehand how IP was such a barrier to certain sustainability issues, but I think that became very clear in your presentation and also in your paper, which was also very well illustrated for each IP separately. So thank you very much. I have three small questions. First of all, in your paper, you discuss how it's required to have technology collaboration and cooperation, which is now being buried or which has IP barriers to it. But I was wondering, aren't there also certain competition law barriers for this type of collaboration and cooperation? Specifically, as you mentioned, that sharing information and technology would be necessary and required to have the type of rapid development that you need in sustainability or to reach a sustainable level. But how would such collaborations be admissible under competition law and more specifically under Article 101 of the treaty? Would this be a new type of consumer welfare interpretation, or how would you think that you could circumvent competition law issues there? Then secondly, you discuss the importance of standardization and EU-wide obligations in terms of technology. For example, you gave the example in your paper of the common chargers that were now being posed by the Commission to use USB-C chargers. I was wondering whether you could elaborate. Do you think that's a good solution? Because I personally thought that would be kind of a risk to stop innovation in some way, because there would no longer be an incentive to invest in a new or a better model, which again runs counter with the idea that you need rapid innovation to reach the sustainability level that we need currently. And then lastly, I have more of a philosophical question a little bit, but in terms of reaching sustainability, I think many people have been pointing out who should be doing this, and often we do tend to go to companies and their engagements also in competition law and in what way they can work together to reach certain sustainability goals. But do you think there should be more initiatives by states imposing certain rules, or should the initiative come more from companies trying to be more greener on their own, so not really imposed by states? What do you think, who is the right actor to really make a change, or should it be more of like a collaboration between those? Thank you.
Thank you very much. Lots of questions. Let me start with the last one. That's the philosophical one, right? To my mind, the state should set the standards in terms of environmental impact, in terms of where we need to go in terms of meeting sustainability goals. That is the role of the state. Industry should come up with technical solutions, but state agencies and regulators are there to facilitate a process of technology transfer. And we have had the successful examples of setting standards in telecom with a lot of experience on how to do this from a competition law perspective. And I guess that is also the idea behind having the EU Intellectual Property Office set up a special unit dealing with standard essential technologies and their licenses. There are a lot of problems and deficiencies, however, still with this model. I mean, ETSI works reasonably well, also in going from one standard to the next, so that innovation is taken on board, so that more or less also answers your question in relation to the charges. Because what you voiced was very much the Apple argument. We can't move to USB-C because we have so many innovative products that will be killed by having this standard forced upon us. You would have to say, well, wait a minute. It means that you can still have technological development. It just means that there is a pathway towards the adoption of a new standard. And this pathway, here you can cooperate as industry, but you have to do so according to guidelines imposed under competition. To my mind here, government should be more proactive. Also because what we see in cases of disputes on patent hold-up situation in relation to brand commitments haven't been given by certain parties, and then still a dispute, typically then it means that there is a patent suit and an injunction is almost automatically given. So this principle of proportionality is also somewhat lost in the discussion quite often. And these are very undesirable situations. And why do these cases still come up time and time again? It is because the industry wants to keep its brand dealings confidential. So there is a complete lack of transparency in sort of the royalty setting in relation to the technology that then is or is supposed to be diffused under friend conditions. And I find it remarkable also if you then ask, so what do you do with the other parties? Can we see the license rates and so on and so forth? The answer is no, this is our trade secret. Can't disclose this, can't expect us to put this on the table. So transparency in the market will be very, very important. And I think there competition authorities and also sort of regulators in these technology markets can play a much greater role. Will competition law be a hindrance then? Well, most of the issues in relation to sort of circular economy are somewhere in the distribution chain. So I would say this is a vertical rather than a horizontal issue. But one thing is clear to me also listening to the presentations this morning, if I think IP law is running far behind the realities of today, competition law may even be further behind. Because many of the problems that we face are not about mergers, but they are about vertical integration and platforms, where through IoT and data gathering and big data analytics, competition law has completely lost sort of grip on market developments, to my mind. So perhaps the upside is that you could do a lot without fearing interference from competition authorities if you wanted to go for a more circular or greener environment. So perhaps there is also the risk of sort of updating a number of the competition laws according to the more German model that we now see in addressing the likes of Facebook or Meta or so. There are risks also that this will extend to other initiatives of vertical integration and further collaboration along the supply lines that may have a positive impact on greening the economy. So that may be a word of warning. Not to throw away the baby with the bathwater.
If I may briefly continue the rant, to what extent is that the core of the problem, and is that what we're seeing? We are all going to get poorer. That is one macro factor. Another macro factor is we have organized our global economy for the last 30 years on the principle of efficiency across borders. That principle is now at the very least being joined, if not being displaced, by more security and redundancy related matters. To what extent, I agree with you, Anselm, we should be far more radical than we are. Should we be even more radical and essentially, recognize, for instance, that economic growth may no longer be, at least in the developed West, may no longer be a legitimate expectation, partially because GDP may not account for greening the economy. For instance, if China, say, moves from coal to nuclear energy, it'll emit a lot less CO2, but if it spends about the same amount of money doing so, it will actually not show up in GDP statistics, so it will count for null growth. To what extent is what we are dancing around essentially sort of around, we're all doing a little dance around a huge campfire, which is our material expectations need to be brutally adjusted, and we're not getting political leadership.
Was there a question there?
No, but the question being, what does it mean for us as researchers when we try and sort of come up with these detailed solutions and incremental action points when the problem is bigger than any of us? How do we tackle that?
Well, even if the problem is bigger than any of us, we should still try to contribute something. I think that is our role also of coming together here and thinking about what can competition authorities do, what can IP policymakers do, what can we do with technology, and what can't we do with technology, and also recognizing that there are opportunities if you radically alter the concept surrounding what economic growth is, and the factoring in of costs. I think Niels may have some ideas about that as well, having done a lot of work on carbon emission trading and things like that. I mean, you can criticize these schemes for not being effective enough, but nevertheless, they have contributed to a large extent to a shift in thinking. Now, the problem of degrowth and discontent is a very difficult one, because we're still facing the discontent that results from globalization. And now that we are moving away from globalization, that also creates discontent. And there, you're right, there is a lack of leadership, but that is a larger problem that we cannot address. What is interesting, though, is that what you now see is this commission is coming to an end. So we will have a next commission sort of coming on. And the idea of that you see is that this commission is sort of setting everything up for the next commission to be able to even develop a more radical agenda moving forward. I find that very interesting. Sort of the idea, okay, there is the window of opportunity, as in the US, sort of with the incoming president, you have about 1 year, 1.5 years to get your policy objectives through, and then the rest of the time is just sort of tinkering a little bit. But that seems to be present very much in the thinking of the Commission. Question is, will the member states actually get on board? Will the Parliament get on board? But I heard you speak this morning about a radical shift in thinking on EU's autonomy and so on and so forth. If EU's autonomy means that we move to green before the rest does, that may not be a bad thing. I'm afraid that, however, and this is what you read in the papers all the time, well, we do have the capacity to produce batteries, but we don't dare to start digging. Not in my backyard. Yeah. I still hope that technology will save us, but it will not save us everywhere. So we may have to make different difficult choices. Okay, I think it's time to move to the next speaker. Good.
You help me with my slides? You do know?
Sorry, try.
Yeah.
So our next speaker is Julian Nowag, and he will also address sustainability issues, but from the perspective of competition law and competition law's sustainable or sustainability gap.
Yes. So I was actually a bit struck when I looked at the panel. I thought, like, oh my God, how I'm going to like talk now after all these IP lawyers, but we did end up talking a lot about competition. So it feels much better to stand here after you. And the other thing that struck me was when I was invited, I was like invited to speak about sustainability and competition law. And I've worked on this now quite some time, and I wasn't really sure what to bring new papers and so on to the table. So what you see here is a bit of a paper that actually I've originally drafted in 2018 and then came out only last year because it was part also of a conference, but basically that conference then led to a lot of developments in the short time since 2018. And I updated the paper then came out last year. But then let's get started. Let's start. I always try to start with a bit of a practical example. And here I have the Indonesian palm oil pledge from 2014 as part of the United Nations Climate Summit. The biggest palm oil producers signed a memorandum saying, well, we're gonna stop buying and selling palm oil, in particular in Indonesia, from newly deforested land. And at the beginning, the competition authority didn't see any problems. But yeah, no problem here. There was a small farmers association. They also said, yeah, okay, that's a good initiative. They were also actually present. However, after some pressure in the background, as I hear, from the big palm oil producers, the competition authority changed its position and said, oh, this is really, really bad. This prevents small farmers from planting palm oil, and they are really relying on this newly deforested land. And they basically said then no to this, or like basically said, well, we have concerns. That meant in turn that these producers abandoned the standard, but in a sense, the same standard was then adopted by the Indonesian government as law. But I suppose you can ask yourself, and I have talked with a couple of Indonesians, and they told me that they are not particularly confident about the enforcement of that law in the deep parts of the jungle. But those are, I think, a very practical example of the interaction between competition law, companies on the one hand, and on the other hand, regulatory regimes. The legislator should do it. They might do it. Maybe they do it well, maybe not. What do they do? And questions of enforcement and so on. But if we are now thinking about this, and that's what I wanted to do in this presentation, is a bit about thinking and helping to think about what competition law can and cannot do. And if we are talking about a sustainability gap in competition law, how do we go about in finding one or identifying where it is? And here I suggest something that goes a while back, and we heard it already this morning, this distinction between what I originally called supportive and preventative integration, which then a colleague of mine picked up and used these nicer terms of shield and sword. But I thought about it, it's not the same. And what do I mean by here? So, and what are we talking about? So first would be this kind of supportive integration shield situation. There, you would have a company that tries to do something that is in the interest of sustainability. And the question then is, somehow, what do we need to do to competition law to allow this to happen? Here, my colleague called it shield. I'm actually not so sure it's always a shield, because shield is about the use. While I think if I look at the competition law or sustainability gap, not the competition law gap, then I think it makes much more sense not to look at the use of sustainability, but rather to look at the outcome. Will we achieve greater sustainability or not? And then we can maybe not intervene and let the companies pursue to allow the sustainability measure. And then the other option is preventative or sword situation, where we can use essentially a strict pro-enforcement agenda to try to achieve a more sustainable outcome. So those are the kind of two things. And then they can work down again in two areas. And that's, I think, what lawyers do. We ask ourselves, is something within the scope or outside the scope? And then once it is within the scope, we in competition law ask ourselves, can we somehow balance sustainability effects and competition law or competition effects? If we want to get to a more sustainable outcome based on company action, we can ask ourselves, we're going to restrict the scope of competition law, say something is not within the scope, and I'll give you examples of all of them. Or we can say, well, this is the restriction of competition, but here we have this amazing benefit of sustainability. And that is, I think in particular, this kind of balancing is where we have a lot of discussion these days. And I think the last 2 years were mainly spent on this kind of balancing, and I'll come to that as well. What we also can see possibly is the other side, where the competition authority tries to expand the scope of competition law to capture things that maybe people didn't think before were so bad, or where we balance then the harms to competition plus harms to sustainability with other benefits of the measures. That's another way of balancing, and that's the kind of stuff we don't see so much yet. But I'll come to that. I forgot to start the timer. Sorry, but I think I have like about 5 minutes. But
You have time.
All right.
Yeah,
Good.
I'll keep the time for you.
Good. Thank you. Okay. So in a sense, what I'm presenting you here is a bit of an instrumental view. Maybe it's an instrumentalization of competition law, but that's not the whole point that I'm making here. I'm not making here a very normative claim where we should go and should not go. It's just like essentially a tool to see and identify gaps, and then we can talk about what we do about these gaps and where we have the discussion and debate. Okay, so is competition law an obstacle? The shield, the supportive, the non-intervention situation. It's the first question competition lawyers always ask ourselves: do we actually need to balance or not? And as I said, this is the kind of main questions that competition lawyers like to discuss. Everything else we forget about. This is where the debate is. This is where you can get everyone excited, but there is more. Because as competition lawyers, we know that not every restriction of commercial freedom is also a restriction of competition. So some things are outside the scope, and we have seen some of these things then later in the Commission guidelines and in the case law as well. But only if something is within the scope, we need to ask ourselves whether we balance the restriction of competition with the improvement of sustainability. So what is not within the scope of competition law? We know that certain activities are non-economic activities, not commercial activities. You see that in the EU, you see that in Australia. You have sectoral exemptions for agriculture, for example, in the EU and US and other countries as well. You might have state action defenses, state compulsion defenses. In the US, there was a car emissions case where the car producers had agreed to comply with stronger standards that the state of California had set after Trump had basically killed off the federal standard. They said, we're still going to comply with the standards in California, and the Trump Department of Justice then investigated that under antitrust law, but most likely dropped the case then because there was a good case for state action because the standard was not set by the companies, but by California. So those are ways to be outside the scope. And then there are questions of no restriction of competition. In the EU, we know loose commitments. If companies agree to say, well, we want to overall reduce our incentives, our plastic usage, our overall emissions from the cars or something like that. In the UK, you had a case on packaging. In the new guidelines in the Netherlands, you have something where you say, well, if we want to comply with laws abroad, we all agree that we're going to comply with the Malaysian, the Indonesian standard on deforestation, then that's not a restriction of competition in the first place. That's questions that are outside the scope. But there is also something very important, which is standard setting. Standard setting, sustainability standard setting has now a separate section in the guidelines of the European Commission. The funny thing is, we do not really get too much of a definition what standard setting is. We only know that if you fulfill the following conditions and you are setting a standard, then that seems to be outside the scope. But what standard setting is not so really clear. And to me, when I look at the cases, also the cases that have now been decided in the Netherlands, which had a couple more cases, I'm always wondering, well, could we not have done the same outcome under the standard setting rules? And what, like, for me personally, I also sometimes wonder when companies seem to be screaming so much, we can't do so little under competition law. Standard setting. You just have to comply with a couple, now it's, I think, 7 requirements. What's the problem? But I haven't got a proper answer to that. So sometimes a bit skeptical of the motivations of the companies because of that. But okay, so let's go to balancing. If we are talking about balancing, we can look into different forms of balancing. We can look what you might be calling a judicial form of balancing or a more kind of detailed economic balancing. So these are the two kind of scales. So we have this kind of abstract public interest balancing, which we lawyers are much more used to. You see that in Australia. You have a public interest balancing in South Africa, in China. You also have these kind of public interest clauses in mergers. For example, in Spain, you even have, was there anyone from Spain? No. Ah, yes. You have that in mergers where it actually mentions the environment. In Germany, you have the general public interest when the minister can basically override the competition authority. And then you have in the EU cases like vouchers, which are also somehow much more abstract, lawyer-focused balancing, where you say, well, you're pursuing this interest and you cannot, you need to be focusing on the proportionality of the restriction. And then you have this kind of balancing within economic or consumer welfare frameworks. And there you have easy cases and more hard cases. So here, I think the common ground is quality. And we heard that already in the morning. So when consumers value sustainability, that is a quality part. We can then think about these quality things, and that's starting to push the boundaries. If we are talking about, okay, so but in sustainability cases, maybe the benefits are not only directly when I consume the good, but those benefits will happen in the future. What about those ones? And what about those future benefits that happen not here, but outside in a different market? And that's where it gets much more difficult. So, for example, if you think about future benefits in markets outside of the one that is affected, maybe we can do some kind of broader efficiency measurement there, contingent evaluation, shadow prices. That's what the Dutch guidelines do now, the draft guidelines, and also to some extent the European Commission guidelines. However, there is still a problem here, and that's where I think we'll come to one of the gaps. And then you can ask, what do you do about this gap? Maybe some gaps we just need to accept. But here is the problem. What do you do with benefits that happen outside of the markets that are affected? So think about a producer of these plastic things here. And they are now all based in, let's put them again in Indonesia. And they are now having an agreement that will make sure that rivers are not polluted in Indonesia. The benefits for the consumers like us here of this product are not really there. When the rivers in Indonesia are not polluted, that is not really a benefit for me. Maybe a quality benefit might be there because I enjoy that when I buy this thing, rivers are not polluted, but maybe that's not enough for the overall benefit to outweigh the increase in costs for this product. So that's the kind of question, and that's maybe where we can identify a gap, in particular with regard to the environment. Even worse or even more difficult with regard to social sustainability. If we are saying we are making sure these companies make sure not to buy this using slave labor, what is the benefit for the consumers that pay a higher price in the EU? There seems to be, beyond the good feeling that we have of not having goods with slave labor, very little. The problem then, however, is that it seems that companies are imposing their preferences or the preferences on some consumers on other consumers, which then have to pay a price for it, while the benefits are not really with those consumers. They are with the slave laborers in Indonesia, with the river in Indonesia, or whatever you want to have it. So that's the kind of area where we might have a gap and where we can discuss how we deal with that gap. And then we can move over to the other section, which is the kind of SWORD, the preventative, the pro-enforcement agenda, where maintaining competition is fostering sustainability. I think we have talked a lot about this here and there. It's essentially the innovation quite often that brings that we are talking about here, sustainability innovation. But we can even be before that, and we can talk about more the common ground, mergers that are reducing in relevant industries, for example, batteries, mergers there might reduce competition there, might be problematic. Or we have a case from France, a hardwood flooring case, where the company said, we're not going to advertise how good environmental performance we have on how hardwood floor, and we're not going to compete on that area. So that's maybe the more common ground. But then you can like start to push the boundaries, and that's where we were talking this morning. Separation, a separate innovation theory of harm. So you see that maybe in Dieselgate, AdBlue cases, or in mergers by Monsanto, where the commission said, well, what happened here? I think AdBlue is a wonderful case in that regard. They said, well, the main harm here is that the companies did not continue to compete on developing better diesel filtration techniques. So that is the harm here. You set a standard and you're not going to compete and trying to get better technology out there into the world. That was the theory of harm. In Bayer Monsanto, that was also investigated. You can then think about whether you push those boundaries even further, and we are seeing that not yet in the sustainability, but in other areas. So mergers, for example, innovation diversity. So different pathways, and that was actually one argument in Bayer Monsanto that the commission had rejected there, where the argument was, well, we want to have different ways of thinking about how to use pesticides. Maybe there are different forms of pesticides that can help us in farming. So things about innovation diversity, different forms of innovation that all different paths that lead to different results in terms of innovation. Illumia Grail and Fitbit, Google Fitbit, were things where the commission has looked at this. Or you can push it even further and you can talk about abusive practices. Maybe poverty in farming might be something that you look into when you're trying to push the boundaries. And this is the kind of thing where we can talk about gaps. And we can say, well, we can fill some gaps, but overall, I don't think there's too much that. So I think we can say competition law can do a lot, but there are gaps. The question is, do we want to fill the gaps? Those are the gaps of out-of-market efficiencies. And this is, I think, the big question we are having been discussing for the last 2-3 years. The social one, which we have mainly talked about environmental sustainability, the social one is possibly even bigger. And then preventative or strict enforcement is also something we haven't seen too much about. And I give you one more example there where we haven't seen much in this area, and we haven't read much in terms of academic work in this area. So think about the following example. There is two companies. They are now having an agreement, and that will reduce the overall production of CO2s from cars. Now, it's maybe even an old example. If you think about it, we are all going to go electric, but okay. Let's stick with the normal cars. So these cars, with the agreement, would all clearly produce less CO2. But overall, the numbers of cars sold and produced will increase, so that the overall effect on CO2 levels is actually negative. So is that something that we should take into account if we are like trying to enforce competition more strictly or not? So those are kind of questions we are only now slowly starting to think about, and those might be gaps where we think about or not. Thank you.
Niels. Yes, I'm going over there because I keep on sitting. Yes. I will fall asleep even though I have to present. So
You realize that the audience may feel the same.
yeah, I do realize that, and it's actually
You can stand up if you like.
you can, yes, please do. And it's already the third time that I'm standing here today, so maybe people are also getting a bit bored to see me here again. Well, some escaped during the second session, so good luck to them. So I'll try to keep it short, but yeah, I still have some reflections of my own on this topic. But I first want to stress that I really think that this paper, even though you presented it modestly in the beginning, I think it's really truly an excellent paper because it brings together literally all of the different arguments and legal possibilities that relate to this topic. So I would just recommend a bit of promotion for you, people in the audience, to read it if you don't already have, so that we don't have to start from scratch every time, because all of these things keep on coming back in each panel. And of course, if you discuss them once, then we're all on the same page and we can go one step beyond, right? So what I particularly like is this classification